stand by while NCLA cuts through the noise to signal abuse of administrative power. This is Administrative Static with Mark Chenoweth and John Vecchione.
Welcome to Administrative Static. This is John Vecchione, and I'm joined by Mark Chenoweth. And the first topic we have to discuss today is the student loan forgiveness of the Biden administration. Some of you will remember that the administration came up with a plan to use the HEROES Act to forgive student loans. And this wasn't passed by Congress, as we've discussed. This was simply the administration saying they could do this. And what we found out is that they are going to push it all the way to the Supreme Court. Now, this, a little background, this program has been stalled because the courts have stayed any of this loan forgiveness. And as the courts have stayed this loan forgiveness, it has gone to the Supreme Court. And this week they had argument in the case that we here at NCLA put in a amicus brief. And because we have one of these cases as well that's waiting on whatever they're going to do. And the argument in the court, I thought the government had a pretty bad day, but Mark listened to it. And what were your thoughts, Mark?
Yeah, I agree with you. I think that the government had maybe a better day than they expected to have, but I wouldn't say that they had a terrific day. And I guess, John, I wanted to maybe start by saying that there are really a couple of different things that you have to look at in this case. And I wanted to maybe set aside the biggest issue in the case.
To go to standing?
That would be standing, because we could talk for this entire hour about standing, because the justices asked a ton of questions about it. And the government might think, hey, that's a good sign for them that so much time was spent on the standing issue. And look, maybe they'll be right. Maybe it'll turn out that the court will dodge the issue and it will decide the case on standing and kick this down. I tend to not think that on such a huge issue that the court is going to whiff, but that remains to be seen. But if we set aside the standing issue, and we can come back to that if you want to, there are really three other things that Solicitor General Preligar focused on. She was saying that secretaries of education from the Trump and Biden administrations had already invoked the HEROES Act to suspend payment of principal and interest during the pandemic. They referred to this repeatedly as forbearance in the oral argument. And so she says this is just a further extension of that unchallenged authority. Well, as you mentioned, John, NCLA filed an amicus brief in the case. And the idea that this is unchallenged authority is not true. We, in our amicus brief, explained why forbearance is also unlawful. So I thought it was interesting that apparently the Solicitor General didn't read our amicus brief, and none of the justices challenged her on that either. But she says that student loan borrowers will be worse off without the relief of the program, because ending forbearance without it will cause defaults and delinquencies greater than what occurred pre-pandemic. And so Secretary Cardona crafted debt relief to ensure borrowers would not be worse off in relation to their student loans. We can come back to that, John, but I thought what was really odd about that claim, she seems to be saying, in order to prevent people from defaulting on their loans, we're forgiving their loans, which is a really odd logic when you think about it.
Well, that is exactly it. The problem, of course, is they have this loan debt and pay it back, but that's a problem for every kind of loan in the country. And I think, though, that the real question on that about how it was unchallenged is, I mean, I thought there was a little bit of, hey, it's not fair. everybody did this, and we just do a little bit more, and I have to come here and argue about it.
Yeah, well, and I do think when they got into the forbearance issue a little bit later in the oral argument, that Justice Thomas, for instance, said, well, maybe that fits a little bit more comfortably under this waive or modify language in the statute. And that's really the other question that was paramount for the justices was, what is the best reading of the text? And the Solicitor General's claim is that the best reading of the plain text expressly authorizes the Secretary of Education to, quote unquote, waive or modify, quote, any Title IV provision in an emergency. And so she says, well, this might be broad authority that Congress is giving, but it's not unclear authority. They've essentially given the keys to the kingdom to the Secretary of Education, and loan forgiveness is a usual form of debt relief. So the fact that it's not mentioned anywhere in the HEROES Act doesn't mean anything. There are other authorities and statutes that apply to the Department of Education where loan forgiveness is a possibility, and the Congress wouldn't have been surprised, she said a couple of times, to see the Secretary acting in the heartland of his authority and consistent with the HEROES Act's purpose and just forgiving $500 billion of student loans.
I thought somebody quoted in one of the commentary on this that Scalia had said, well, that modify, you could say that the French revolutionaries modified the aristocracy by putting them through the guillotine. So
right.
I thought it was a lot of you. I thought that was a regular funny Scalia line, but modify can go a little far if you use it that way.
Modify can go a little far, and Chief Justice Roberts brought up Scalia's quip and from the MCI case and said, look, you're talking about pretty significant changes here. And she said, well, first of all, Congress had given those authorities, and that this wasn't just modify, this was waive or modify, and that waive or modify is broader language. Now, when it came to be his turn, Solicitor General Campbell from Nebraska, and there was a little oddity in this oral argument, John, that almost the entire argument revolved around a Missouri entity, Mohila, and yet it was the Nebraska Solicitor General who was doing the oral argument. And I assume that there are sort of behind the scenes reasons for that. But
I was wondering that as well, because there's this Mohila question where Mohila is a state educational entity that did not sue. The Missouri sued for it. And there was a ton of argument there that isn't enough, that the state has to have direct injury, not from this company that didn't sue. I don't know how that's going to fly. I mean, I thought if they're a state and they have this sovereign entity that they own as a sovereign, this entity, and they're injured, I think that should be enough, but I don't know.
So you want to get into standing?
Yeah, I think you have to a little bit. I mean, that is.
No, I mean, this soon you want to get into standing, but that's okay. We can jump to standing. I just to me, it's the least interesting part of the case, because it's very hard to predict what the justices are going to do or what the logic is going to be. I think you intimate, John, what the straightforward answer is, which is to say, look, 77% of Mohila's revenue comes from servicing direct loans. About half of those loans will be discharged under the Secretary of Education's program. That's going to cut Mohila's operating revenue from direct loans in half. So Mohila is going to have less money as a result of that to give to the state of Missouri. And there's this back and forth about this Lewis and Clark fund, and Mohila hasn't donated to that for 15 years. But the Solicitor General said, well, but wait a minute. The reason they have not donated to that for 15 years is because there's been an ongoing negotiation with Mohila, and under that negotiation, Mohila has been giving $65 million, not a small sum of money, to a different state scholarship fund. And so that's what its annual payments into that scholarship fund won't happen anymore, or won't happen to the same dollar level as they've been happening in the past. That's the claim of the state of Missouri, and that they can stand in as for Mohila and represent Mohila and complain about the fact that these funds won't be there to fund scholarships for Missouri students going forward. I think that's the easiest answer. Maybe the second easiest answer is, look, this is a state instrumentality. the state can speak directly for it. It was created by the state. It's doing public activities. End of the story. And Justice Amy Coney Barrett seemed like she might be looking for an answer that simple, John.
Oh, good. She asked about that.
She did. But there was lots of pushback from other justices. Justice Jackson asked if there are offsetting fees that might allow MOHELA to go ahead and pay its money, and might MOHELA just go ahead and spend all the money it has to sort of make good on this one payment it makes, and sort of disregard all of the other financial obligations that MOHELA might have. The Solicitor General, I think, rightly said it's hard to think there'd be enough offsetting fees to make up for that. It's hard to believe that MOHELA would be able to make the payments if its revenues are cut in half. Justice Kagan talked about the fact that MOHELA can sue and be sued. It could have shown up to complain about this if it wanted to. It didn't. And that SCOTUS usually doesn't allow standing in the shoes of another by third parties. What Solicitor General Campbell said in response is that the government is a little bit different, and that there are federal cases. And John, you may be familiar with these cases. I am not. One case called Cherry Cotton Mills and another case called Erickson. And he said that those cases have allowed the federal government to assert interests of federally created corporations. And all that the states are asking for is for Missouri to likewise be able to assert the interests of a state created corporation here. When you think of it that way, it doesn't sound like a very extensive increase, if any increase at all, in the doctrine of standing. And in fact, Justice Alito pressed Solicitor General Preligar on this point, because she was saying, well, you'd be doing something unprecedented if you recognize standing here. And he said, well, we've never weighed in on this either way. It's going to be unprecedented no matter which way we come out on this. We'll be back with more right after this. Welcome back to Administrative Static. Mark Chenoweth and John Vecchione talking about the oral argument at the Supreme Court this week in the Biden v. Nebraska case about student loans. John, I think we tied up the standing question there at the end of the previous segment, but there's one major topic that we have not gotten to yet, which is applying the major questions doctrine. And Solicitor General Preligar was very insistent on the plain text reading of the statute, even though it has breathtaking scope, because she then wants to say that applying the major questions doctrine to override clear text would put the judiciary in the position of overriding the will of Congress in order to deny critical relief. And she did not, she got some sympathy for that position from the justices appointed by Democrats, but she did not get much sympathy from justices appointed by Republican presidents on that point. I think there was some sympathy for her reading of the text, but the idea that the major questions doctrine would be shunted aside wasn't something that I heard a lot of support for, starting with Chief Justice Roberts, who jumped in pretty early on to say to make the point that you made about modification, but he also seems to think that Congress could easily be surprised by the idea that borrower relief specified in the HEROES Act would lead to total loan forgiveness. And Preligar tries to take the case of forgiving a single soldier's debt under the HEROES Act, and then tries to say, well, if that forgiveness is possible, if you admit that the text of the statute allows that one soldier's debt to be forgiven, then our program has to be allowed too, because this is just an extension of that same principle. And I think that is where the major questions doctrine comes into play. Justice Sotomayor picked up on the mention of the $500 billion and asked if that alone made this a major question. And Preligar said, no, it can't just be economic. She offered additional factors why this case is not in major questions doctrine territory. And one of the things she said, John, is that this is the administration of benefits, not a regulatory action that impinges on individual liberty. I don't know if you have thoughts about that. Justice Alito wasn't buying that. He kept asking if there was some sort of, he said, look, the separation of powers still comes into play. And it's not as though in benefits programs, Congress says, well, $1 trillion here and $1 trillion there doesn't really bother us. So he did not see a distinction as to whether the doctrine would come into play in the benefits context versus the regulatory context. But the Solicitor General was trying for that distinction. But
I guess, given the makeup of the Supreme Court, you got to go with textualism, don't you? I mean, where's she going to go?
Well, arbitrary and capricious is where she went. She tried to say essentially that, if I'm going to lose this case, I want to lose it on arbitrary and capricious grounds, not on a statutory interpretation of the HEROES Act that says that the Secretary of Education can never do this, or that the major questions doctrine would prevent the Secretary of Education from enacting such a program. She would prefer for the court to say, well, the Secretary didn't make sufficient findings here. He didn't tailor the program sufficiently. The lines he drew were somehow arbitrary and capricious, and therefore the Secretary gets a do-over, send it back, and we'll try to tidy up the program a little bit, maybe cut it back a little bit and try again. If they strike down the program and say, look, the text of the HEROES Act does not allow loan forgiveness, then they can't go back, at least not under the HEROES Act. Justice Kagan raised a few statutory arguments about whether the relief was quote unquote necessary, or whether maybe it made borrowers better off. And she was on board with the idea that these were arbitrary and capricious sorts of inquiries, not statutory interpretation arguments. And so obviously Preligar readily agreed with Kagan about that. And she says, in a world where the statute tolerates overbreadth and allows class-wide relief, which I don't know that was stipulated by the states, John. It wasn't stipulated at oral argument. I don't remember seeing that in the briefs. But in any event, she said, assuming class-wide relief is allowed, the question is justification of the line drawing that took place, and all the Secretary's noting of the tremendous financial impacts of the pandemic are enough from her perspective to justify the lines he drew for arbitrary and capricious purposes, which, if you're in an arbitrary and capricious world, John, then that is a lower standard that the Secretary would have to meet.
Yeah, although I will say this, is that like an APA argument?
Yes.
Well, they would much rather lose on the APA than anything, and I can see Kagan going there if she can get 5.
They would rather lose on the APA. The interesting thing here, though, is that under the HEROES Act, because this is an emergency authority, you don't have to go through notice and comment rulemaking. And, maybe we should touch briefly on, there's so much we still haven't talked about from the Biden v. Nebraska case, but maybe we should touch briefly on the Department of Education v. Brown case, which was the second case argued, John, because that's where that issue came up. That essentially what the Brown plaintiffs are saying is look, we're part of the 5% that was excluded from benefit under this program, and we think that if this rule had gone through notice and comment rulemaking, we would have been able to comment, and we would have pointed out certain aspects of the rule that would have led the Secretary to include us, sort of broaden the program and include us within the program. But because they went under the HEROES Act, where they don't have to do this, we were excluded. And so what they're saying is essentially there's authority under a different statute, the Higher Education Act, to do some sort of loan forgiveness like what he's done. But if the Secretary had gone under the Higher Education Act, he would have had to go through notice and comment rulemaking. It would have taken a lot longer. Maybe the president wouldn't have gotten the political benefit of a quick loan forgiveness sort of rollout before the midterm elections. And so he didn't do that. He went through the HEROES Act instead, but that's not allowed. And there was a lot of back and forth over whether that sort of bank shot kind of complaint is even something that can be raised. I mean, forget about, so there's a standing implication there too, right? Do you even have standing to challenge what happened here when you're talking about a different statute? There was a lot of back and forth on standing. I think that there was more skepticism toward the standing of the Brown plaintiffs than there was the standing of the states in the Biden v. Nebraska case.
And there's a conflict, right? The states are saying this is all an illegal action, and they're saying we weren't included in the illegal action.
Well, and I think it was Justice Sotomayor who said, this is a little strange what you're doing here. You're essentially trying to say that you want the program expanded, and the way to expand the program is to eliminate it entirely. And you're just assuming that the secretary is going to come back with a different program that includes you if you do that. So, I mean, I think she's wise to the fact that the folks who are challenging this maybe don't have the best interests of loan forgiveness in mind. I think that that came out, that the tenor of some of the questions, I think, betrayed some skepticism on the part of the justices that these particular plaintiffs were really all that exercised about expanding the program. And maybe once it was abolished, they would be happy to just sort of end the story there. But I think maybe one thing we need to talk about, John, that we haven't talked about yet is Justice Kavanaugh, because as you know, one of my favorite topics, in this case, he seemed to agree with the Chief Justice and Justice Thomas that Congress could have said cancellation, as they've said in other statutes, but they didn't. That text isn't in the HEROES Act. And so he said he said, look, this looks like an old statute with general language and a massive new program, that it smacks of the sort of Brown and Williamson UARG line of major questions doctrine cases. And he asked, why doesn't this fit that line? And Preligar offered that this new program is consistent with the purpose of the HEROES Act, that Congress said all provisions could be waived or modified, and that the secretary wasn't acting outside of his subject matter lane. So when you have the CDC dealing with an eviction moratorium that's a housing policy, maybe that's not in the CDC's lane. But here you're talking about student loans, and the Secretary of Education, that's his lane. And that's the core of his expertise. And so she felt like we were out of major questions doctrine territory for that reason. But Kavanaugh did not seem completely convinced about that. He ended with sort of a big picture question about the court's finest hours being when they had pushed back on executive assertions of emergency authority. And I think he's thinking like of the steel seizure case in the 50s during the Korean War, for example. But Preligar said there's less reason to be worried about executive power in the benefits context. And John, Justice Kagan said, well, we worry about executive power when Congress hasn't given it to them. But when Congress has given it to them, then it's okay. And I thought, wait, what Constitution is she reading? That's not, the separation of powers is a guarantee for the citizens. It's not the case that when the executive branch and the legislative branch team up and say something's okay, that everybody else has to move to the sidelines. That's not just because the Congress is okay with handing legislative power over to the executive branch and combining those separate powers under one entity, as this statute appears to do, John. That doesn't mean that that's not a separation of powers problem, or that everybody else doesn't get to complain. I think that's I thought that was an unfortunate sort of thing. So I guess maybe time for some predictions, John. We've got about a minute left. I predict final standing for the states is more likely than for the individuals. I predict that the major question doctrine rides again. The amount of money here is ginormous. The chief is obviously bothered by it. Kavanaugh is bothered by it. If you have them on board, then I don't know that there'll be much explicating of the doctrine, because this seems so much like the previous cases. The major difference is that this statute is the Department of Education's to administer, but I don't think they're going to make this change about the benefits context. I don't think that the Solicitor General is going to get her wish to lose on arbitrary and capricious grounds. I don't think the court will reach the appropriations clause question. We didn't even get to that. But I think the Chief Justice will write the opinion and assign it to himself. We'll see.